Well, hello everyone. I'm Jarlath Curran. I am the chair of the CMBA's Legal Issues Committee. Thank you very much for joining us today. We have two fantastic speakers to get us up to date on RESPA and the activity with the legislature. Before I get to our prestigious speakers, I first wanted to give a thanks to the sponsor of the Legal Issues Committee, CDF Labor Law. We have Ashley Halberta here, so I'm going to hand it off to Ashley to say a few words.
Thank you, Jarlath. As he mentioned, my name is Ashley Halberta. I work for CDF Labor Law, which is an employment defense law firm located in California. We have 5 offices, and we can help you and your companies with anything from advice and counseling to actual litigation. If you do end up getting sued or cease and desist letters, we've been doing a lot of those recently, as well as if your employees request their personnel or payroll records files, we handle those as well. So any employment related issues you have, we have a lot of companies in the mortgage industry as clients. So we understand what you do and we know how to help.
Great, thanks Ashley, and then again thank you to CDF Labor Law for their sponsorship. It's very much appreciated and very helpful.
Thank you.
So now we'll turn to our speakers. First, I'm going to introduce Alan Lindeke. Alan brings firsthand experience in every facet of the mortgage origination process. Prior to beginning his legal career, Alan worked in every facet of mortgage origination, from origination, processing, and underwriting to closing. He was also a branch manager and even ran his own mortgage brokerage. This hands-on experience, combined with his unparalleled knowledge of relevant laws and regulations, allows him to offer unique insight into solving real-world legal and regulatory issues with minimal impact and disruption to related business units. Over the past 11 years, he has served as the Chief Compliance Counsel for several mortgage lenders, fintechs, financial institutions, and diligence providers. Along the way, he obtained his CRCM designation from the American Bankers Association. Most recently, he was general counsel at a well-known national lender where he dealt with multiple legacy repurchase program matters. Legacy repurchase litigations, mergers and acquisitions, security offerings, and community-focused lending program matters. Given this successful track record, he was recently named a finalist for the prestigious Los Angeles Times In-House Counsel of the Year Award in 2023. Very excited to have Alan here with us. Also, we've got Robert Finley. Robert is the founding partner of Wright Finley & Zach since '94. Robert has focused his legal career on consumer finance and mortgage-related litigation, compliance, and regulatory matters. Robert is at the forefront of the mortgage banking industry, handling all aspects of ever-changing default servicing and mortgage banking litigation arena, including compliance issues for servicers, lenders, investors, title companies, and foreclosure trustees. Robert successfully guides clients through the complexities of litigation while being extremely mindful of their core values and business models. Robert is a regular speaker and contributor with the CMA, CMBA, MBA, and UTA. Since 2019, Robert has proudly served as general counsel for CMA, advising the board and its members of a variety of loan origination, servicing, and other legal and compliance issues. Robert is also my old boss, so always happy to see him. But anyways, I will turn it over to Alan. So Alan, the floor is yours.
Sounds great, thank you. Today we're going to be going over the recently issued CFPB's guidance on internet and mobile marketing, piggybacking off of the 1996 RESPA CLO policy statement. It was more of a refresh rather than a new interpretation of law, although they do get into very granular specifics on what they would and would not consider to be referrals pursuant to Section 8. Next slide, please. So giving you kind of a history lesson, back in 1992, in the final RESPA rule, the HUD issued an exemption for CLOs. And for these computer loan origination systems, RESPA Section 8 did not prohibit any payment by a borrower for computer loan origination services, as long as the CLO fee disclosure, which was set forth in Appendix E, was provided. In 1992, it created a lot of ambiguity on how that applied to payments made by lenders. So if the lender made the payment to the CLO, would that fall under your normal Section 8 analysis? And HUD's interpretation was yes. In 1994, they proposed limiting the exemption to what they refer to as qualified CLOs. And that would limit the exemption to CLOs having, quote, characteristics HUD considered beneficial to the consumer. As you all can probably guess, that's a very vague and ambiguous term that would be very hard for industry to comply with. Ultimately, they elected to abandon that approach, citing changes in technology and in its use would repeatedly make the safe harbor obsolete. Next slide, please. So now we fast forward to the 1996 HUD opinion letter. So it was the 1991 HUD statement regarding computer loan origination systems. And in 1996, they also revised the RESPA rule to remove the CLO exemption in its entirety. In 1996.1, they said to the extent a CLO performs settlement services, it is a settlement service provider. If a CLO does not perform settlement services, it is not a settlement service provider. Kind of stating the obvious, but I put down below that a settlement service provider under RESPA is any service provider in connection with a real estate settlement, including but not limited to the origination of federally related mortgage loans, including but not limited to the taking of loan applications, loan processing, underwriting and funding of loans, and the handling of the processing and closing or settlement. Now, I will tell you that Reg X, it's in RESPA's implementing regulation, actually goes substantially further in the definition. Reg X says any service provided in connection with a prospective or actual settlement, and then they include 15 individual bullet points listing out basically every step in the loan process. So that essentially is going to expand the definition of settlement services to, in this case, anybody who's marketing or advertising or soliciting a mortgage loan could be providing settlement services. Next page, please. So just a little backtracking on the prohibition against referral fees. RESPA Section 8 prohibits referral fees, and ultimately the CFPB's guidance is all predicated on what they would interpret in a digital marketing place to be a referral fee. So our prohibition on referral fees says no person shall give and no person shall accept any fee, kickback, or thing of value pursuant to any agreement or understanding, oral or otherwise, that business incident to or a part of a real estate settlement service involving a federally related mortgage loan shall be referred to any person. Then you fall back on to the 8C2 exemption, and the 8C2 exemption is the exemption that, you know, Cordray in PHH, there was a lot of controversy on, where Section C2 says nothing in this section shall be construed as prohibiting the payment of to any person of a bona fide salary or compensation or other payment for goods or facilities actually furnished or for services actually performed. The value of the referral, though, is not taken into account in determining whether the payment exceeds the reasonable value. So essentially, if the value is reasonable and proportionate to the service provided, it's generally not going to be payment for a referral fee. If you're not performing any settlement services, or if there's value on top and the value is inflated, the CFPB will generally infer that whatever extra value is given given in contemplation of a referral. Next page, please. So Section 8, generally the 4 elements you have to have is contemplation or expectation of a, and then they say thing of value pursuant to an agreement understanding. And I will tell you, they define thing of value extremely broadly. And in the CFPB's new alert that was published on February 17th of 2023, they make abundantly clear that thing of value is very broadly interpreted. So there's some guiding principles around Section 8 that any payment must bear a reasonable relationship to the value of goods, facilities, or services provided, and any charge for which no or nominal services are performed, or for which duplicative fees are charged, are unearned fees or referral fees. Next page. So in HUD's opinion letter, they spent a lot of time talking about controlled, or what they refer to as controlled business arrangements, which we generally refer to now as affiliated business arrangements, and when those are permissible. I know with the market where it is right now, that's a hot topic with people trying to figure out how they can form affiliated businesses to be able to take part in different aspects of receiving compensation. And under RESPA, it says when consumers are referred from one business entity to an affiliated business entity, a written disclosure of the affiliate relationship must be provided. There can be no required use. The referring entity cannot require the consumer to use the CLO, or the CLO cannot require the consumer to use an affiliated company listed on the CLO. And the only thing of value that is received by one business entity from another business entity is in the controlled business arrangement, other than payments permitted for services actually performed, is a return or ownership interest or franchise relationship. So essentially what they're saying there is that you can't, just because you have an affiliated business does not mean that you have carte blanche to charge for anything that you want or pass money freely between the businesses. The CFPB and HUD will look at, first and foremost, was there compensation for the service performed? Was it reasonable? Was it consistent with what would be generally charged? And then if you had equity that was left over at the end from the entity that earned the equity and it was distributed to the owners through the ownership, that then itself violates Section 8 of RESPA, but it doesn't give you carte blanche to skirt Section 8. They also talked in the RESPA rule about the employee exemption quite a bit. The CFPB kind of glances over that. They don't really contemplate that much at all in their new rule, but employees are generally exempted from Section 8 of RESPA if you have referrals that are kind of intercompany or referrals made by an employee to an affiliate. But again, don't forget about your licensing and LO comp rules if you're going to be having referrals passed back and forth from individual employees that may or may not be licensed depending on the scope of work they're performing. Next slide, please. So this is where the CFPB and HUD, this is kind of the part of the HUD rule that the CFPB really focused on. And they really focused on non-neutral displays of information on settlement service providers. So HUD may scrutinize non-neutral displays of information on settlement service providers and their products because favoring one settlement service provider over others may affirmatively influence the selection of settlement service providers, which could constitute a referral under RESPA. If there is an affiliate relationship between the CLO and a favored settlement provider, the non-neutral presentation of information under certain circumstances could constitute a required use in violation of RESPA. The CFPB's position changes a little bit to get to the same answer for a little bit different reasoning in their opinion. This guidance on non-neutral displays should be read to discourage CLOs from assisting consumers in determining which products are most advantage to them, or should not be read. And for example, if the CLO consistently ranks lenders and their mortgage products on the basis of some factor relevant to the consumer's choice of the product, such as like who's giving the consumer the best APR, and the APR is calculated to include all charges and to account for the expected tenure of the buyer, HUD would consider that practice as a neutral display of information. But to the contrary, if they were to place like their preferred providers on top or their affiliated providers on top, give them better presentation, those would be things that HUD would have been looking for in determining whether it was a non-neutral display. Next slide. So this is where the CFPB comes in, and the CFPB focuses on digital mortgage comparison shopping platforms, or DMCSPs. The advisory opinion focuses on digital platforms that include information or features that enable consumers to comparison shop options for mortgages and other settlement services, including those platforms that generate potential leads for platform participants through consumers' interactions with the DMCSP. Now, the reason I highlighted the consumers' interactions are this opinion was not intended to be applied to like advertising to the general public. If you have something going on where there's no interaction with the consumer, then it's not going to be deemed a DMCSP, so the guidance wouldn't apply. This is not intended to be applied to purchasing of liens or anything of that kind of sort. Applying the HUD CLO policy, settlement service providers may pay CLOs a reasonable fee for services provided by the CLO to the settlement service provider, such as having information about the provider's products made available to consumers for comparison with the products of their other settlement service providers. Moreover, if the CLO lists only one settlement service provider and only presents basic information to the consumer on the provider's products, then that would appear to be no or nominal compensable service provided by the CLO to either the settlement service provider or the consumer, only a referral, and any payment would be a referral fee. So essentially the CFPB is saying that if you are going to have a CLO or a DMCSP out there marketing and they're only going to be listing your products with very limited information, you're really not providing much value. If they're interacting with the consumer, it's a little bit squishy there, because when you start thinking about how much interaction are they really having, if they're only presenting basic information and providing one lender, it's like how much interaction are they really having, and does that really touch on the rule anyway? But nevertheless, the CFPB mentions that in here. Next slide. So non-neutral presentation referral fees. So essentially a non-neutral presentation that would equal a referral fee would be the DMCSP non-neutrally uses or presents information about one or more settlement service providers participating on the platform. That non-neutral use or presentation of information has the effect of steering the consumer to use or otherwise affirmatively influences the selection of those settlement service providers. Referral fee, and the operator receives payment or a thing of value that is, at least in part, for that referral activity. DMCSPs receiving higher fees for better placement equals a referral fee. And if an operator of a DMCSP receives a higher fee for including one settlement service provider compared to what it receives for including other settlement service providers participating on the same platform, the CFPB said that can be evidence of an illegal referral fee, even absent other facts indicating that the payment is not for enhanced placement or other forms of steering. So if you're a DMCSP and you're running a digital platform, you would be very wise to be very consistent in your payments and how you're placing things. I think the CFPB may be overstretching that a little bit, in my opinion, when you're saying that somebody's paying more, but they can't demonstrate that you're giving them anything of value back in return. But nevertheless, the CFPB made the statement, it's in their opinion, so you would be very wise to follow it. Next slide, please. Non-neutral use of information. The CFPB said manipulating or biasing of inputs or formula that the operator employs to generate the comparison options before they are presented to the consumer. So essentially, if you're going to go in and you're going to give greater weight to one attribute that a lender has that may not be in a neutral basis, that would end up displaying people that pay more, for example, we get higher placement, or people that are your preferred lenders would get better placement. Any type of manipulating or biasing of those inputs would be a non-neutral use. It allows operators to steer or affirmatively influence the consumer to select certain platform participants by non-neutrally using information to generate comparisons, as opposed to being completely neutral. Next slide. And then the CFPB goes into a lot of examples. They get very granular in this opinion letter. For the sake of brevity and time, I listed out the examples for you guys, and I want to make it very clear the CFPB has indicated in this that not only that they are focusing on RESPA Section 8 a lot more, which I imagine they would, you know, as the mortgage industry tends to get tighter and there gets less loans out there to originate, and lenders are fighting over them more. People come up with more creative ways to steer business their way. And I think this is the CFPB's response to some things they're seeing the settlement service or digital marketplaces are doing to try to force traffic to one lender versus another and make more money. So they said not providing same information on all lenders would be a violation. So if you had one lender that's paying less, not getting to put a web link on there, but the lenders are paying more, getting a web link, that would be problematic. Like any pay for play or steering to the highest bidder or preferential placement for affiliates, payments only from and promotion of lenders who rotate to a top spot. Do not grant lenders better placement for consumers with second visits to the website. So they talked quite a bit about that, where if you're going to give people better placement if the borrower comes back a second time, which indicates they're probably more likely to sign up, and that would be something the CFPB would look at as impermissible under Section 8. They talk a lot about warm handoffs. They even go on as far as to say, even if it's done in a neutral way, it may evidence exclusivity. And again, I think they're stretching the outer bounds of Section 8 with that a little bit more than they probably should, because the way they described it was essentially you have like the first person who picks up the call on the lenders you have gets it, so it's completely neutral. They said that they've even issued consent orders based on those facts. Follow-up text messages to preferred clients undermines the neutral presentment, and implied endorsements like you're in good hands or those kind of things are per se not allowed. Next slide. So CFPB will infer that a referral fee has occurred for non-neutral placement, things of value, likely that an agreement or understanding for referrals can be established under Reg X through a pattern of practice or course of conduct. So even though they don't show anything directly, they will infer something wrong is going on. If the payment for a thing of value bears no reasonable relationship to the market value of the goods or services provided, then the excess, of course, would be a referral fee. And the fact that a transfer of a thing of value does not result in an increase in any charge made by the person giving the thing of value is irrelevant in the CFPB's mind in determining whether the act is prohibited. The CFPB will infer a referral fee for higher payment. So if you have one person paying more than the other, they will infer that that is for a referral fee. And the CFPB states paying the same fee if non-neutral presentation is still a violation of Section 8. So just because you're charging people the same fee, if you're presenting the information in a non-neutral way, that still violates Section 8 according to the CFPB. Next slide. Now, this is the part where HUD and the CFPB really differed. The CFPB went into a very long diatribe where they essentially said that it doesn't matter whether or not you have an affiliated business relationship exemption. They said higher rankings are a thing of value and they are not just for return on equity. They do not meet the C2 exemption, so that is a referral fee. So if you're giving your affiliates higher rankings, even if they're paying the same or anything else, the CFPB said you cannot do that. Next page. Essentially, DMCSPs are allowed if the operator receives payment from the settlement service provider for their participants on a DMCSP that both neutrally uses and neutrally presents information, is receiving payment for commensable services, and thus be compliant. And then they added in a little caveat, assuming no other facts were present that would call such RESPA Section 8 compliance into question. And then they gave a couple, then I want to go over if we had any additional time. A couple other things that I've seen around Section 8 recently. It's only going to take a couple seconds, but I know we're running short on time. Realtors, they're asking, like we've had builders and realtors calling, asking if they can buy down blocks of interest rates. We had one builder ask if they could prepay ahead of time for like $3 million of lower interest rates. I've seen realtors requesting that we hire their family members and pay their family members some fee outside of any services they're providing. We've had people can approach us about co-brokering relationships. And also, you know, I've seen this quite a bit, especially in Hawaii, where they're forcing funding to occur 30 days before recordation of the deed of trust for non-preferred lenders, essentially taking any non-preferred lenders out of the marketplace. So with that, I think that's all I had. Next slide. And I think we are on to Robert. So without any further ado, I will pass this on to Mr. Finley for his legislative update.
Thanks, Alan. Appreciate it, and great job summarizing some complicated stuff. I must admit, though, when I was listening to your bio, that I realized I need to up my game a little bit. It sounded pretty darn impressive to get going.
Well, thank you.
So, and Jar, by the way, you're welcome back anytime. All right, so I'm going to talk about the 2023 legislative session. We're still in the middle of it right now, but just kind of go over what has happened thus far, and then I'm going to hit upon some bills. So there was over 2,000 bills that were proposed to begin with, and keep in mind that when these bills are proposed, unlike many other states, California allows like a placeholder. So you could propose a bill that just says, I want to make the world a better place, and then later on, you know, a month or so later, you then can add in that, you know, doing so would add significant regulations to the mortgage industry. So you can have these placeholder bills. So our lobbyist Indira McDonald, who has done a great job taking over for Pat Zanzola, who had been our lobbyist forever, along with Susan and Sam and the entire legislative committee, go through those bills to identify which ones could have an impact on the CMBA and its members. And you know, with the bills constantly changing, it's a big job. So the team was able to identify a couple dozen bills that have potential negative impact on the CMBA and its members. The bills that right now where the bills lie, so you have AB, which means it was originated in the Assembly. You have SB, which means it was originated in the Senate. Bills have passed their respective houses right now, and then they're on to the opposite house, where they can be amended yet again. So we have to continue to watch them in the new house. Both houses are currently in summer recess for about 2 months. They'll come back on September 14th, and then we'll have a flurry of activity between September 14th and the end of September. And then the governor will have until October 14th to sign or veto any bills that pass both houses. Next slide, please. All right, so one of the bills that has caught our attention, we spent a lot of time on, is AB 1033, and this involves accessory dwelling units. And by way of background, you probably noticed over the last 5 years or so, California has passed a ton of laws supporting ADUs. And really what most of those bills have been focused on is preventing cities and counties from denying you the ability to build an ADU. So state law says you can do certain things when it comes to ADUs, and it doesn't matter what the city, county, or an HOA may say to stop you. So it's really taken a lot of independence away from the cities and controls. So cities can't deny an ADU because of concerns over, you know, the impact on the infrastructure, the impact on parking, the impact on schools. They can't do that. So they have to approve certain ADUs up to certain sizes and within certain specifications that the prior bills laid out. So with that done, and it was done to try to encourage development of ADUs with the goal of trying to cut down or lessen our housing shortage that we have right now. And what the last couple of years, what the legislature has been focused on is figuring out how to allow you to sell the ADU separate and apart from the existing unit. So I got a house, I go ahead and build an ADU in the backyard, and now I want to go ahead and sell that separately. The legislature believes that if it can be sold separately, then it'll increase the available housing and also further encourage people to build ADUs. So that's what their goal is. And they believe that they found a way, after some failed attempts in the last couple of years, to accomplish that. And what they want to do is they want to allow to use the existing condo conversion statutes to allow for ADUs to be sold separately. So you would use the existing condo statute, and in the situation I gave, I would create Unit A, Unit B. The Unit B is the ADU, and then I would be allowed to sell the ADU separately. So it's attempting to use existing law, and the argument being, well, it works for condos, so why won't it work for ADUs? Well, there's a lot of reasons it may not work for ADUs. Title companies and their associations are really have been fighting this because of all the problems it'll create from a title standpoint. So it looks like the bill, though, may go forward, even though the title companies are still fighting it. Fortunately, the CMBA, along with the coalition of lenders and others in the industry, were able to get in a requirement that in order for the ADU to be sold and in order for the ADU to use the condo conversion statutes, they must get the approval of all lien holders on the property before they can go ahead and do so. So that means for the people on the call, you don't have to worry about suddenly your property being split in two without you knowing about it. You have to agree to it. You have to sign off on it. And generally speaking, you're probably not going to want to do that unless you're a lender that specifically is lending on these types of loans, or you believe that the value is going to be there even after you allow the ADU to be sold off separately. We are waiting for GSE input on this because I think whether the GSEs are going to approve this or how they want to handle it will have a significant impact on whether the law in its current state passes. So this is the big one. It will create some opportunities. It'll create some problems. I think ultimately the legislature is going to get something passed, and I think the governor will sign it. Whether this is the year and this is the bill, I don't know yet. So we're keeping an eye on that one. And but the biggest thing is right now it will require approval of all lien holders, which I think is very helpful. So next bill. So in our next bill, and I'm not going to cover all these in the same amount of detail. There's some of these I'm going to hit on with more detail like the last couple, but then some will breeze over pretty quickly. So this one here we've been paying a lot of attention to as well. It is SB 567. It involves rent control. So there's already a certain level of rent control in California. They break it out to no fault and fault. If the borrower fails to pay rent or commits waste on the property or violates various laws, that's fault, and you have the right to evict them. There are no fault grounds where you can still evict under certain circumstances, and the legislature is targeting two of them by this bill. First, they feel that owners are abusing the ability to evict tenants with the idea that they're going to move in themselves or move in a designated family member, a child, a grandparent, something sibling, things along those lines. And they also feel that owners are abusing the ability to evict tenants to do a major remodel or to demolish the property. And so they wanted to pass some additional laws to kind of regulate those particular practices. Then they also wanted to, there are some limits already that exist on your ability to increase rent. So landlords can once a year increase rent by the CPI plus 5% or 10% total, whichever is less. Previously, that the CPI was about 2%, so you add 5 to that, we were about 7%. Now that's much higher, so the 10% cap comes in. They feel that landlords are demanding higher amounts to take advantage of tenants who may not know their rights. So they wanted to target that as well. So what this bill proposes is it would require owners who displace tenants with intent to move into the property themselves or an approved family member to continuously occupy the property as their primary residence for at least 12 months. So you can't move in for a month and then move back out. How much that was being done, I doubt it was being used as much as the legislature thinks, but this is where they're coming from, what they're trying to stop. Second, they would require owners who displace tenants for purposes of a major remodel or demo to provide the tenant with a detailed notice of the work to be performed, estimated duration of the work, and then you actually have to complete the work. So you can't tell someone you're kicking them out to do a major remodel and then not do it. And then it creates a private right of action for the tenant as well as the Attorney General's office to enforce violations of those provisions. So it creates some teeth. And then lastly, it would create a private right of action by the tenant as well as the Attorney General to go after any landlords who request rent above the allowable limits that I provided previously. And in addition, it would allow for treble damages, which is really a fancy legal word for triple damages of up to 3 times the excess demand if the landlord acted willfully or with oppression, fraud, or malice. So again, it creates some teeth for those landlords who may be asking for more than they're entitled to, with the hope that the tenant won't speak up and won't know their rights. So this bill is moving forward. CMBA has been actively involved in trying to limit it, and we'll see what happens down the road. But I think it will pass, and I do think the governor will ultimately sign it. Next slide, please. So this one here is this is your CMBA legislative committee and DERA at work, because we were able to get an exception, because this would have been a problem. So you may have read the federal and the state level, there's a lot of discussion about junk fees that are added in. So you agree to buy something or rent something, and you don't know what you think it's going to cost $600, and the next thing you know, it's $750 with all the additional fees. They want those fees disclosed, and it prohibits advertising for goods and services that do not include all fees, excluding those taxes. So as originally drafted, it would have included real estate transactions and real estate loans, which would have been a major problem, requiring a lot of additional advertising. And then you'd have to get into, well, how far down the line do we go when it talks about fees? If you make a loan, ultimately down the road, what if there's property inspection fees by the servicer? Those are potential fees, so they would have to be disclosed. It would have created a nightmare for our industry. Luckily, the CMBA, along with an industry coalition, were able to get the real estate loans and transactions exempt. So this is something we don't have to worry about as of right now. We'll keep an eye on it to make sure the ultimate bill that passes is still in line with that exception. So great work there, and we dodged a bullet. Next slide, please. So AB 1448, another bill that was another one that we dodged with some effort. It originally created a super lien for violations of cannabis property. So if there were code violations on a property, which there are often, those code violations or any fines against an illegal operator would have a super priority, which would negatively affect all of your loans and create a title nightmare as well. That super priority portion of the lien has been removed. The bill is going forward, but that super priority portion has been removed. So there will still be a lien, but it'll just be junior. Next one, or not next slide, but next bullet point here. SB 278, financial elder abuse. This one was causing us a lot of concerns as well. So basically, there's already elder abuse laws on the books that if anyone who commits elder abuse, there's criminal sanctions, there are monetary sanctions. What this bill proposed to do is anyone who aided or abetted someone else who commits elder abuse could also be liable or criminally or civilly for elder abuse. So just aiding and abetting would be the equivalent of committing elder abuse. And where it would have impacted the CMA and its members is arguably, allowing a loan to go through, even though you didn't know it was elder abuse. Arguably, that could have been claimed to be that you were aiding or abetting. So they created a process whereby if you think there could be, if you think there could be elder abuse going on, you could report it. The way it was written, pretty much any loan to someone over, over I think it's 55 or 65, any loan that to someone over that, you would have reported it every single time, and you would have had to wait 15 days for the Adult Protective Services to give you the clear, which would have created a nightmare for any seniors trying to get loans. So luckily, the bill has been, it's now a 2-year bill, which means it's essentially been shot down for this year. Doesn't mean it's going to go away forever. It may pop back up next year, but I think the authors of the bill realized you would almost be harming seniors more than you'd be helping them. So good work by Indira on that one as well. Next slide, we have AB 1345, exclusive listing agreements. So the legislature is concerned that real estate agents are going out there and getting extensive listing agreements for, we've heard up to 99 years. So if you ever want to sell this property, you're going to have to use this particular agent. I have not seen that, but that's what the legislature claims is out there. I believe, I could picture someone doing 10-year ones or something like that. And they wanted to prevent consumers from being taken advantage of by limiting it, the extent of a listing agreement to 12 months. Realtors are okay with a restriction, but they're pushing for something like 3-year exclusive listing. I don't know why you would ever need a 3-year exclusive listing other than trying to tie up a property and take advantage of that particular owner. So we'll see whether it's 12 months or 3 years, but at least there'll be some restriction and prevent any abuses. Next bullet point, please. So SB 455, loan servicer disclosures, this is going forward and probably will pass. It would require certain disclosures for loan servicers when there's an agreement made for repairs to a property following a natural disaster. The concern here was that not all the required disclosures were not enough disclosures were being made to borrowers when entering into agreements to repair the property. They didn't understand what was going on and the interplay with insurance proceeds and having to repair the property. They also felt that when loans were being transferred or sold, that the new servicer wasn't aware of that agreement. So this bill would require certain disclosures and would require that agreements be passed on to the new servicer, but it would only apply in a situation of a total loss. So the CMBA was able to negotiate certain amendments that lessen the impact on servicers, but it's still likely to go forward and likely will pass, but it's much more palatable for servicers. Next slide, please. AB 1043 was sponsored by the United Trustee Association, and it's their latest effort to clean up SB 1079, but basically technical cleanups. But and SB 1079 is the post-foreclosure auction process that has been in place for a few years. They added, in addition to some technical cleanup, they added in something to protect consumers from being taken advantage of, but when there's excess proceeds. So with the market so hot and with third-party purchasers coming in and buying properties at foreclosure sales over and above what the lenders owed, there have been a lot of excess proceeds left over. And this law would prevent anyone from contacting, soliciting, or initiating communication with the prior property owner for at least 90 days afterwards. Give them the opportunity to hear from the foreclosure trustee, learn that there are excess proceeds, and then make a determination, an educated decision themselves as to what they want to do without being inundated with all of this, with all of these people trying to help them get their excess proceeds for a fee. AB 968 targets house flippers who resell properties within 18 months of purchasing it. It would require that the flipper must disclose to the buyer, the prospective buyer that's buying the property within that 18 months, all renovations, all permanent information, including room additions, structural modifications, repair, etc. There's a few more things that are identified, as well as the name of every contractor who worked on the property. The idea is they want to make it more difficult for flippers, and then also make it give borrowers the power of knowing what exactly the flippers did. The bill has passed both houses and is currently on the governor's desk, and I'd be shocked if he didn't sign it. Next slide. SB 666, commercial lending fees, would prohibit a CFL licensee from charging certain fees on commercial loan transactions that do not provide a corresponding service to the borrower. We were able to get loans that are secured by commercial properties to be exempt, because this was mainly charging other types of commercial loans where there were a lot of fees being added into the loan. So commercial loans exempt, great job by this CMBA and its lobbyists. And then 696 is RON, which is remote online notary. Every year there's a bill. This year there's two. This one here has still got some problems, but ultimately something's going to pass, and this may be its year. Next slide. So with running out of time, so I included a few slides here, just some bills that I thought you might find interesting. And some of these were shot down, some of these will pass. I'm going to skip over there. I don't think we need to talk about them right now. So we could jump ahead to slide 19. In 19, once you get there, but it's going to be AB 331. I wanted to mention it's automated decision tools. Those are coming more and more into play in our industry. And this bill would require developers of those automated decision tools and the deployers, the people that use them, to provide impact assessments for those tools on an annual basis. The bill currently appears dead, but I wanted to mention it because it could come back in the final weeks in September, but also if it doesn't come back this year, it's going to come back next year. They want to make sure, the legislature wants to make sure that these automated decision tools are not having an inappropriate impact on various groups. Next slide. Pending issue that we're watching, we understand that many hazard and fire insurance carriers have pulled out of California, which obviously creates a problem. There's less options out there, and there's the prices are going to be higher and already are higher. We just wanted to point out that the CMBA is actively engaged in conversation with the insurance carriers and trying to bring them back in the industry. The hope also is we're trying to work with Commissioner Lara to get her to re-engage the carriers that have left the state and bring them back. Hope we can provide some pressure and try to get them back in so our consumers have more options. And last slide I'm going to cover real quick, and then we'll leave it open for some questions. I wanted to point out some other bills that we were watching in other states. So you can, if maybe you make loans in those states, but if not, it's just important, I think, to see what's going on in our neighboring states, because those things may come back into our states. So Nevada AB 223 would have required a debt collector in Nevada to provide a payoff letter within 10 days after being requested, which would have been fine, but what was required in that letter was very onerous. And it was shot down. It passed, but then was shot down by the governor. Just kind of goes to show you the climate in other states, even in a state like Nevada, where this seemingly wasn't a terrible bill, and I'm sure in California probably would have been passed and signed by our governor, was shot down. Nevada SB 395 would have limited the amount of units that an investor could buy in a calendar year. Last year, California proposed some bills that would have been restrictive on the amount of units that investors could buy. From a different angle, it would have imposed in California a capital gains tax on them. That was luckily shot down last year. This one in Nevada failed. Arizona HB 2412 would have taken California's post foreclosure auction process, which is we call SB 1079, to Arizona. It failed, never even got out of the gate really. Utah, a bill passed, which actually is a good one if you're making reverse mortgages in Utah. It lowered the age for reverse mortgages to 55, and that has been passed and is now law. Florida, SB 254, this is an interesting one, and it passed, I say surprisingly, but some would say not surprisingly from Florida. But it was effective July 1st. Chinese foreign nationals are only allowed to purchase one residential property up to 2 acres as long as it is more than 5 miles from any military institution or installation of 10 acres or more. If the translation violates the statute, the property is forfeited to the state. What happens to your loan is a very good question, and that's something that is going to have to be worked out. The ACLU filed for an injunction, and there's been briefing on that. So this bill may, well, it's a law right now and it's not enjoined. It may end up getting enjoined down the road. I thought this was interesting because California actually proposed earlier this year a law that would have prevented foreign nationals, not just Chinese, but other foreign nationals, from buying property near military installations. It died and didn't really get going. But this is an issue that seems to be causing many legislatures concern. And I think it's something that you're going to see pop back up in the future. And I think there's going to be a lot of obvious fight over it. Some people in favor of it, and some people not liking targeting certain groups. And then the last bullet point, Sam, if you could, is at the federal level. And this one here was, it got a lot of press a week or two ago when it was initially proposed. And at the federal level, they always have catchy slogans with every act. So this is Stop Predatory Investing Act. It would stop investors who buy 50 or more single-family homes from deducting interest or depreciating those properties. And this is up for serious discussion. We're going to have to track it and see where it goes at the federal level. But again, it shows, we had the law in Nevada this year. We had one in California proposed last year. There's a feeling that investors are coming along and buying, single-family homes, which is changing neighborhoods, which is increasing prices and preventing, homeowners and new buyers from buying property. They're being priced out of the market, and that they're the cause for, our, housing affordability issues in various states. So this is an interesting way to approach it. It's basically, if you buy over 50, you wouldn't be allowed to deduct interest. I don't know if that's really an issue, because I think a lot of these are being bought with cash, but you'd also be prevented from depreciating these properties. So we'll track that and see how it goes, because I think that would affect many people in the real estate field and people who make loans to those investors. So that's all I have. We'll open it up to questions. A lot of material, and if anyone has any questions, happy to answer them now. If you'd like to email me, you're welcome to do that as well. This is usually the part where there's complete silence, or do we have some questions?
We haven't had any questions come in yet, but yeah, as Robert mentioned, there is a Q&A box on your guys' control panel. You should be able to see. If you have any questions for our presenters, feel free to go ahead and submit that there.
All right, Alan, next time we gotta give Jar some easy softball questions for us, just in case.
Hey, I have a question for you. So in that Florida case with the ACLU, where's the injunction stand right now?
I think it is fully briefed, or will be fully briefed in the next week. And then I'm sure there'll be a lot of argument. I would expect a decision probably mid next month.
Excellent.
All right, well, I am not seeing any questions in the chat.
I covered them all during the presentation.
All right, yeah, well done, gentlemen. So again, thank you, Alan. Thank you, Robert. Very informative, very helpful. Really appreciate you both taking time out of what I know is a very busy schedule to come here and present for our members. So thanks again, and thank you everyone for joining. I hope you all have a great rest of the week.
Thank you.
I just wanted to add a thank you to Indira, our lobbyist, and the CMBA Legislative Committee. They worked really, really hard to make a lot of headway on some of those bills that I was telling you about, where they were a problem, but they're not now. So if you ever see any of them at the conferences, please thank them.
Absolutely.
Right.
You guys, thanks everybody for joining. Have a great rest of your day.
Bye-bye.